Contracts and agreements are essential documents in any business transaction. They serve as legally binding agreements between parties and provide clarity on responsibilities, obligations, and expectations. However, not all contracts run their course smoothly. There may come a time when one party needs to end the agreement early, either due to a breach of contract or a change in circumstances. In such cases, termination and cancellation clauses come into play, providing a means for either party to exit the agreement. In this video we'll explore the importance of termination and cancellation clauses in contracts and agreements. What are termination and cancellation clauses? Termination and cancellation clauses are standard provisions in agreements that dictate how either party may end the contract or agreement. These clauses are critical in defining the conditions, events, or actions that trigger the termination or cancellation of the agreement. In most cases, these clauses provide a clear set of rules and procedures for ending the agreement, helping to avoid confusion, ambiguity, and disputes that may arise when terminating or cancelling a contract. Why are they important? Termination and cancellation clauses provide essential protection for both parties in a contract or agreement. They are particularly crucial in situations where unforeseen circumstances may arise, such as natural disasters, changes in the law, or economic crises. For instance, if there is a change in regulations that makes it impossible for a party to fulfill their obligations under the contract, the termination or cancellation clause provides an exit strategy for both parties. Similarly, if a party breaches the terms of the agreement, such as failing to make payments or not delivering goods as agreed, the other party may terminate or cancel the contract, thereby protecting their interests. In both cases, the termination or cancellation clause provides legal clarity on the rights and obligations of both parties, reducing the risk of disputes and legal action. What should they contain? Termination and cancellation clauses should be carefully crafted to ensure they meet the needs of both parties in the agreement. They should provide a clear and concise set of rules for ending the contract or agreement, covering the following key areas. Triggering events. The clause should specify the conditions or events that trigger the termination or cancellation of the contract. For instance, it may be a breach of contract, a force majeure event, or a change in circumstances. Notice periods. It is essential to specify the notice period required for terminating or cancelling the agreement. This helps to provide clarity on the length of time required for both parties to wind up their affairs and prepare for the end of the contract. Procedures. The clause should detail the procedures required for terminating or cancelling the agreement, including any legal or administrative requirements. Consequences. The clause should also provide information on the consequences of terminating or cancelling the agreement, such as the return of deposits or the payment of damages. What are the risks of poorly crafted termination and cancellation clauses? If termination and cancellation clauses are not carefully crafted, they can lead to confusion, ambiguity, and disputes in the event of an early termination or cancellation. Poorly written clauses can have serious consequences, particularly if they do not adequately protect the interests of both parties in the agreement. For instance, a poorly written termination or cancellation clause may not specify the triggering event, leading to a disagreement over whether the contract can be terminated or cancelled. Similarly, if the notice period is not clearly defined, one party may not have sufficient time to wind up their affairs, leading to economic losses or disputes. Conclusion. Termination and cancellation clauses are essential provisions in any contract or agreement. They provide a clear set of rules and procedures for ending the agreement, protecting the interests of both parties and avoiding disputes. It is essential to craft termination and cancellation clauses carefully, taking into account the specific needs and circumstances of each agreement. Doing so ensures that both parties are protected and that the agreement can be terminated or cancelled smoothly and with minimal disruption.